Thanks, Edward. Hey, good afternoon, everybody. This is Tom Clark. I'm the 2020 president of the Spokane Association of Realtors. Welcome to today's Zoom roundtable. We have an E&O, Errors and Omissions panel today. And just for the benefit of anybody observing, watching, or participating, know that this is going to be recorded. So if you have an aversion to that, you probably don't want to view it. We're going to record it for the benefit of our membership that cannot be here at this moment. So Darren Watkins today is our Government Affairs Director and will be our moderator for the event today. Ken Sachs is with us. He's this is kind of his brainchild, and I'll let him introduce that. Our format today is pretty simple. We have some set questions that we felt were something that we'd want to make sure that is covered in this format or in this forum, and also we welcome anybody participating or observing to use the chat function, and we'll do our best to keep up with that. So without any further ado, let me introduce Ken Sachs so that he can start the procedure.
Great, thanks, Tom. Hi, folks, and thanks for being here. And yeah, this came out of our membership committee here from the Spokane Association of Realtors, and the goal was to increase engagement with our designated brokers, our firm managing brokers. And so I thought, well, what's really relevant today? What's going on? And what am I dealing with as a designated broker? And of course, insurance claims, errors and omissions. And that's a lot of what I get from just talking with brokers around the state. And so I thought, well, it's really timely. Let's bring in some panel experts to talk about E&O and what we can do as practitioners, as DBs, as owners of companies to minimize, I won't say eliminate, but to minimize our exposure so that we can do good business in as safe manner as possible. And so this went from Spokane brokers to now the whole state's been invited. So again, thank you for being here. And I'm going to push this on to the panel experts now so they can give a brief introduction. And we'll start with Mike Richardson.
Yeah, I appreciate it, Ken. Mike Richardson, I work for Pro Group International. And what we do is we are E&O specialists for real estate offices. And we've been doing it since 1989.
April?
I am April Anderson. I am a shareholder at the firm of Randall Danskin in Spokane. My practice is focused primarily on real estate and general corporate work. And I'm sitting here with my partner, Shane McFetridge, who I work with pretty regularly on litigation. So I'll let him introduce himself here.
Good afternoon. Shane McFetridge, also a shareholder at Randall Danskin. I am a litigation counsel, including real estate matters as well as other civil matters outside of real estate, but happy to participate today and looking forward to the roundtable.
Great. And Mr. Peterson.
Hi, my name is Brian Peterson. I work with Mike Richardson at Pro Group. I was in a sales position for many years. I've gone on, I'm actually president of our company and run the sales force and operations here. I've been in the errors and omissions world specific to real estate since 2003. I just want to thank you all for taking some time to listen to us.
Great. Darren, I'll turn it over to you.
Fantastic. Just a couple of ground rules. So for our purposes today, the Q&A function has been disabled. So if you have a question, just go ahead and put it in the chat box and we'll watch for that. And second of all, if you have any other browsers open right now, you might want to close those. We found that it greatly enhances the performance of your computer if you just have one thing at a time. That's one thing we've really noticed in our recent Zoom meetings. And we'll try to keep this as open as we can. This is just a great conversation to talk about legal issues. And as always, if you have a real question about the law, you should contact someone who's a professional specific to your issues. We may use some terms today. So while we're talking about errors and omissions, oftentimes we vernacular those to be E&Os. So just watch for that. If that's confusing, E&O does mean errors and omissions. And the reason why we're bringing this today is because with a lot of changes that are happening in our industry right now, especially where there's such little inventory, we're seeing a lot more offers being made. We're seeing a lot of offers having to be made fast. And those sorts of things, they tend, you would think, to make errors. Let's find out what that. Mike, let's ask about that really quick. How are errors and omissions comparing today for realtors, say just 10 years ago?
Darren, yeah, what we're seeing is there's just, it's skyrocketed, honestly. I don't know if that's just part of the market's been really good. More transactions means more chances for errors, but I would say since I got in the industry in '07, the amount of claims I've seen has probably tripled. It's just nonstop.
April and Shane, if we could ask you, what about the merit of these claims? Do you just seeing more claims that we're just having to be a more litigious society, or are they really having merit?
Well, in our experience, we see these things being somewhat cyclical based on the economy and the way it's doing in general. So right now, in our practice, and specific to this issue, we're seeing a lot of claims and just a lot of dispute work in general. So when things are depressed and people are anxious, they tend to want to fight more about pretty much everything that comes across the table. And so, you know, we saw this after the market crash in 07, 08, and we're seeing it again now. And the merits are fact-based. I would say, you know, it depends, but a lot of claims get settled before they ever end up in trial. So, you know, there is a potential for settlement when insurance is involved, which motivates people to make claims. They don't really have a whole lot to lose in submitting the claim in the first place. So I don't know if you have anything to add on that, Shane.
Yeah, by the time something gets to my desk, a lawsuit has been filed. I am seeing more of that than I did in the past. And I agree with April that the trend seems to be when the economy starts to sour a bit, folks do start paying a little bit more attention to issues with their house. They start looking more closely, of course, at their own financial situation. And you start to get these types of lawsuits typically over things with their house or things about the sale itself that they were not happy with, and now they think they're going to try to do something about it to improve their situation financially.
Brian, you're the president of your organization. How do we compare in the Spokane region to other regions? Are we better, worse, the same? I mean, kind of what do you see trend-wise?
You know, that's a great question. It's all relative. When I talk to folks, and we're licensed in 39 different states, so we have a good feel for the entire country. The thing I tell folks is if you're in California, you're in the most pain. It is beyond unbelievable what we see in California. There was a time and place that we were told if you took a set of scales and you put California's E&O costs on one side and the other 49 states on the other side, it would balance out. Now, I feel that's a bit overstated. With the same point, California is very difficult. New Jersey, Texas, those are your three hottest points. But when we get to the northwest part of the country, Oregon and Washington are getting hot very quickly. It's not to say that you all are doing anything more wrong than the next person on the block, but the reality is your real estate markets are very hot. They're competitive. We have bidding wars. And when people do not see the return on investment that they felt they should have had on that property, that's when we see the lawsuits. So to answer your question at the beginning, I would say you're in that top quarter of risk in the country today.
Interesting. Just an aside, by the way, if you're hearing some weird rumbling or roaring noises in our audio, it's because outside SAR today we're having the parking lots are being done. And so the heavy equipment sort of rattling things here. If that comes through on the microphone, it's not your speaker. Don't smack your computer. It's from us. Ken, from a local perspective, you run a brokerage that when you see these mistakes, do you try to catch them all, or what's your process for trying to mitigate these issues in-house?
Well, something that I talk about a lot is material communication. And I just always push our brokers to have as much material communication as possible in your transaction file, because it seems these things come up well after closing, let's say, and then the licensee is faced with an accusation that occurred 14, 15 months ago. And they're sitting there like, I don't know, I don't remember. So thankfully, we have material communication. Our Department of Licensing has required material communication. And I always get the question from brokers, well, what is material communication? I said, anything that can save your hide in the future, that can counter some accusation that's being made against you. So in my mind, it's talking with professionals like who we have on the panel to understand what best practices are, but having that material communication to help you defend yourself in the event of a claim.
You would imagine that younger or entry-level folks, we have a lot of new folks coming into the business, would make mistakes, but is that true, or is it something that happens across the board?
Is that to me?
Mm-hmm.
I say it's across the board. You know, when we come to like our contracts and our language within the contracts, some of the newer folks have a better understanding of those contracts than the veterans who maybe aren't as familiar with all of the revisions that we've had over time across the state. But it's everybody's a target, and no time in the business is irrelevant, because I think, as was implied earlier, a lot of cases don't have any merit. And so you can have good, clean, solid business and still find yourself with the crosshairs on your forehead because somebody wants money and they talk to somebody who says, oh, here's an opportunity for us.
So let's take that the next step. So Mike, we've gotten the complaints, or that now people are coming to you, and the first thing that lands on your desk, what's the first thing you do when you screen that complaint? Mike, we could talk about that.
You know, honestly, I don't deal with the complaints. That would probably be a little better question for April and Shane.
Okay.
For me, I kind of help them report it and see what the issue is, and then since I'm not an attorney, I leave it to the experts on that.
So the first stage here. So April, let's ask you about that. When you get these complaints, is what Ken says is true, or what percentage would you say have real valid things behind them? And then how much of this is just emotional driven?
So, you know, it is very fact-based, and usually when we get a demand of some sort, that's how it starts.
Okay.
And you don't necessarily get a complaint filed in a lawsuit in order to trigger coverage. So I think that's something that can trip people up. They don't really necessarily understand that the way your insurance policy is written typically will encompass things such as demand letters if there is a demand for damages, monetary compensation, and a threat of litigation. So what you want to do, you're not at that point going to have enough information to determine the validity, at least I won't, of the underlying claim.
Mm-hmm.
But what you don't want to do is risk not getting coverage under your insurance policy because you don't tender this claim you've received in the form of a demand letter. So what we will often do is say, you need to talk to your broker and provide this demand letter before you ever even get a lawsuit filed, potentially based on what's included in the demand. And then as we start looking into the situation in the letter, or if we've received a complaint, we can start, determining if there's any validity to the claims. But oftentimes, depending on the experience of the plaintiff's counsel involved, they will have crafted legal arguments that are pretty broad, several different types, to potentially trigger insurance coverage, knowing that the insurance is going to be available as a defense. So, that's really what we see when the process comes across our desk. And I don't know if Shane has anything to add to that, but.
Yeah, as I said before, by the time something gets to my desk, usually a lawsuit has been filed. In many cases, I don't see the cases or the claims that are really have merit, because if somebody, throw in a football reference, if there really was a flag on the play and somebody did something that maybe they shouldn't have done, that gets resolved, and I don't ever see those. The ones that I see are where the parties have genuine disputes about whether there was in fact anything done wrong. And so when I get that, there really are two key things that we do to start with. One, to touch on what Ken said, we have to find out what happened, which oftentimes means going back months, sometimes even years, to try to reconnect or put back together the events that transpired. And that's where documenting your file really is key at the time, so that you can, when you sit down with me months, years later, you can show me, you know, here's the email I sent that covered this issue. Here's the document in the file that demonstrates that I did, in fact, do what I said I did. That is very, very important for me to help you defend the lawsuit. The other issue is tendering the claim to your insurance carrier. When we try to do that, if it hasn't already been done, that's also the thing that we do immediately in connection with investigating the underlying merits. And depending on the type of insurance coverage that you have, it can be very important that you tender right away. As we work through some of these questions, I know we'll get into more detail about insurance. I don't want to go on at this point because I think I've made my point in response to the question at hand, but it really is important as you work through how to report your claim, what kind of insurance you have and when you need to tender it.
Right. And then mitigation is clearly a key part of this, right? We try to work with the parties, and at some point, whether it's in your court, Shane, where you're trying to mitigate a settlement, or Ken, if it's in your court, where you're trying to talk with the folks early on, mitigation really is the key to all of this, isn't it? Ken, we'll start with you.
Yeah, mitigation is the key, but I'm not ready to move on from what Shane was saying, because I think this is a really important point for brokers and designated brokers, and that is with regards to tendering the claim. Like, what does that even mean? Because we, as licensees, and especially DBs, we're getting threats, I mean, almost fairly regularly, right? And so when does that threat cross the threshold of me obligated to report it to my insurance company? And if I don't report it to my insurance company, that could result in them not covering us if that gets pushed up the flagpole. And so I think it's really important to just kind of pause on this, where as we're dealing with all these threats coming in, remember at a certain point, and maybe April or Shane could explain, what is that point where we have, or Mike, where is that point where we have to then send it to our insurance company as a heads up, and then is that going to count against me? So if I send up like I tender 4 different threats within a 30-day period, are they going to not renew me or raise our rates when none of those threats actually resulted in a claim? It's really key to understand this to our listeners here, because it could break you if you don't tender that.
Great question. So we'll start with you, April and Shane. When is that triggering point? When do you see the difference between the two issues Ken's bringing up here?
Well, there are really 2 ways to look at it. The first way is to review your insurance policy. Claim is something that is oftentimes defined in your policy. There will be a definition of what actually a claim is. So taking the time to review your insurance policy periodically, make sure you understand when a claim is actually triggered for purposes of making sure that you're timely reporting those issues that needed to be reported to your insurance company is key. Sometimes insurance policies don't have a definition of claim, and so you have to look outside of that to try to figure out, okay, I got this communication. Is this something that I really do need to tell my insurer about? And in general, the definition, if there isn't one in your policy, the general definition in Washington is when a claim for compensation is made to you. So in other words, I was wronged, you need to pay me something, or you need to do this to make it right. Anytime an affirmative request is being made of you to respond to a complaint, I mean some sort of communication, not necessarily a lawsuit, any type of written or oral demand that you do something to provide someone else compensation is and could be considered a claim under the law. So once we get into the realm of you need to do something to make it right for me, that's when it's time to tell your insurance company about it.
Okay, Mike. So now it looks like we're coming to you about this process. So when do you want to hear from Ken? And when do you want that process and that engagement to start?
Yeah, and just like Shane said, and I apologize, they are mowing right behind my window behind me. So if you guys can't hear anything, I hear a weed eater going too. So it's just wild back here. But like Shane said, when there's a lot of times it's an email that says, I want so much money, otherwise I'm going to sue you, or I'm calling my attorney. We want to know about it then. I tell Ken, I'd rather you call. We turn it into the insurance carrier and say, hey, we've got an incident report. We may not turn into a full claim, but we're going to disclose to you what's going on. It'll show up on your loss report, but if nothing happens, it goes away, then it's not going to penalize you next year. But worst case scenario, 6 months from now, this crazy buyer comes back and they still won't go away and an actual lawsuit comes in. Well, if we didn't report that initially, most policies give you 30 or 60 days to make them aware of an incident. And if you're past that window, they very well could deny coverage. So it's better to be cautious on that stuff, especially if you're shopping carriers and you're switching carriers, because if you switch carriers, a lot of times the new one's going to, 99% of the time say, well, you had a prior knowledge issue. You knew this guy was upset and it could turn into a claim. You should have turned it into your old carrier. And that's the last thing we want to deal with is claim denials. But like they said, that's the number one reason we see them. It's somebody didn't report it in a timely manner, or they thought they took care of the problem and it came back later, and the carrier said, well, you should have told us 6 months ago when they first started complaining to you.
If I could jump back in to dovetail what Mike just said, now is probably a good time to just generally explain the difference between what's called a claims made policy, an insurance policy, and an occurrence insurance policy. Typically, insurance policies provide coverage for 1 calendar year. So if your insurance policy starts January 1st, 2020, it'll end on January 1st, 2021. If it's a claims made policy, anytime you get a claim, you have to make sure that you report it to the insurance company within that coverage year. And if you don't report within that coverage year on a claims made policy, they can deny coverage. An occurrence policy covers anything that happened within that calendar year, regardless of when you actually make the claim or notify the insurance company of the claim. So the way that would play out potentially is if you have this policy in place for January to January 2021, as I just described, a claim happens in October, but a lawsuit doesn't get filed until January or February. If it's an occurrence policy, you're fine. There's going to be coverage, even though there's going to be coverage for that event that happened in October, even though the lawsuit was filed in February, because that policy covers everything that happened that year. If it's a claims made policy and an event occurs in October that you are aware of with respect to a potential claim, but you don't report it to your insurance company, and then the lawsuit gets filed in February, there might not be coverage because you didn't tender the claim within the policy coverage year. So that's why it's very, very important to know whether you have an occurrence policy or whether you have a claims made policy.
So Mike, given that information, what advice do you give to your clients?
Well, and with real estate, I don't know that anybody sells an occurrence policy anymore. There might be one I'm not aware of, but we work with 20 or 25 different carriers, and everyone I see is a claims made policy. So it's important right before your renewal date. If you're aware of any potential issues, you got a bad gut feeling about a transaction, a disgruntled buyer, let's put an incident report in just to be safe, because like Shane said, your policy renews, maybe they come back a month later and complain. Well, they said, well, why didn't you tell us about this before you renewed? We should have turned this in.
Brian, I'd like to ask you about this as well. What are you seeing industry-wise? Is that kind of a direction the industry is going, or where do you see things heading?
Yeah, we've been on a claims made basis for quite some time, and I don't see anything changing anytime soon. I do want to step back to something Shane mentioned earlier. He discussed turning a claim in within the boundaries of your policy. It's his example, January 1 to January 1. We don't want folks sitting on things all year at the same time. If you find knowledge of something in February, please don't wait until December 31st to turn that in. And Shane is right. In 99% of the cases, we're in good shape. That's not going to be an issue. But I would just say, if you have a concern, that demand, that monetary ask has been submitted to you, please go ahead and turn it in at that point. But to go back to your question there, Darren, no, it's going to be claims made going forward. I don't see changes in the future. This is one of the hardest concepts that we deal with our clients. The whole world thinks the carrier I'm with today is going to handle the issue that's in front of me. Mike had a client here a couple of years back. They called in on an issue, and it had occurred 8 years ago. It had not been discovered for 8 years. And every state's a little bit different, but most are 24 to 36 months. I'll leave on Shane in April for the state to make sure, but it's from the discovery of that issue. So we're talking 8+ years from a closing, and these folks are being sued. And the confusing part was they may have been with a carrier 8 years ago that's no longer even selling insurance, but we've transferred them over to Travelers or General Star, one of our partners, and they're going to be covered, and it goes forward. So it's just an interesting concept that gets lost on a lot of our clients. And if you're an owner broker and you're considering selling or buying a company, I would advise you to have a good discussion with your broker and make sure they understand claims made policies. Because if you try to exit that policy, you may have a fat bill coming to you. You just want to be prepared for that if you're thinking about selling.
We have a question in our chat room from Daphne. Now, Ken, I'll start with you. What are the most common errors we're seeing with errors and omissions when you work with these contracts?
Well, I don't know if I'm the best one to answer this. And this is a claim that actually has merit, which I'm not all that familiar with claims that actually have merit. So, maybe Mike or Brian, as far as what are the common claims? The ones I hear about are disclosure issues, seller's lack of disclosure, and then the licensee ends up getting sucked into that because we have the insurance policy, the seller doesn't, even though it was a seller disclosure issue.
Yeah, a lot of them I see. It's most of the time, probably 90% of our non-disclosure issue. Maybe there was some water damage that wasn't ever disclosed, that your bathroom flooded, and then they put some paint over it. Now they're having a mold problem, something along that line. Discrimination claims have been picking up a little bit. I think part of that is just because more people are renting than used to in the past. And, one of our carriers has told us this week that their rate in property management, their rates are basically tripling because they're starting to get claims related to COVID. I'm assuming it's because they're not getting, tenant issues and wrongful evictions, something along that line. Those have really picked up. And then I see a lot of sewer versus septic misrepresented on a disclosure form. I feel like I see one every other month, and it's a really big deal, or a misrepresentation of the actual property line. Those are pretty common too. And then I don't know, Brian, if you could think of anything else that's real common we've been seeing.
Yeah, I tend to agree with Mike and Ken. To start off with, the numbers that the carriers are telling 90% of the time it's going to be a non-disclosure issue. And to Mike's point, property management's more dangerous than it used to be. Don't be surprised if appraisal comes into play here shortly, which some of you folks in this call may have a little hand in that. The one thing that we always want to keep in mind, and I can't speak to every single policy out there, but Mike and I have most likely touched or sold every one of them out there at one point in their time. Fraud's not going to be covered. If you're intentionally breaking the law, that's a no-no. And commission disputes will not be covered. So if Mike and I are arguing over $1, the E&O companies aren't going to assist you on that side. So just a couple things to think about there.
April and Shane, the same question for you. What are some of the more common mistakes that you're seeing that have merit?
So Ken mentioned, the seller disclosures, and as we all know, the brokers are responsible under the statute, just as the sellers are for the contents of the seller disclosure statement to the extent that there's actual knowledge of conditions. So failure to state something, omitting information that's known, or misrepresenting information. And that is true also with the condition of the property generally. If something becomes known or was known prior to entering into the agreement, that has to be disclosed as well. That creates liability for brokers. Fraud is not covered, so we'll often see these claims couched in negligence. So you've got your negligent misrepresentation, your breach of duty to your own client for failure to comply with your statutory duties as a broker, being negligent and not getting things done for a timely closing, kind of blowing it on price information if you're giving some kind of specific comparable information to your client, things of that nature. I don't know if you've seen anything else or if you have specifics.
No, everybody hit the nail on the head. Far and away, the majority of claims that come to my desk are misrepresentation claims, something to do with the condition of the property that the buyer alleges the seller and or his broker knew about that they failed to disclose. And that could create significant problems because attorneys who may not be in tune with insurance issues as much as they should be will style their lawsuit to say that somebody intentionally or fraudulently misrepresented a condition about the home. And as everybody's commented, fraud is something that's typically not covered. So that is a very tricky thing to deal with when you're trying to get insurance to come in and defend the broker, but at the same time, the person that filed the lawsuit isn't doing you any favors when they're saying that something that you did was fraudulent. So yeah, that's it. Unfortunately, while it's the most prevalent thing I see, it's also one of the most difficult things to do in terms of securing coverage for your client.
Would you say that's the most difficult case for you to actually work with, is issues where along the way it's discovered there was something done fraudulently?
Yeah, it is, and it is really the most difficult thing to deal with because of that dynamic where you're trying to get the insurance company to cover your client and pay for their defense, and you're just not getting any help from the other side who has filed a lawsuit because they're saying that you did these bad things. Now, ultimately, it's not collusion, but I have had conversations with plaintiffs' lawyers where I explain to them in a roundabout way that you might want to consider if you're going to file a lawsuit to include a negligence claim and include a claim that says that what I don't personally agree with it, and we certainly will defend it, but putting in the lawsuit that the broker negligently or failed to comply with a standard of due care, and that resulted in the problem, actually helps them because then they know there's going to be insurance coverage to respond to the claim.
So I have a question. So I'm listening to this, and I'm a listing agent. I list a lot of properties, let's say, and I hear that a lot of the claims are around non-disclosures through the sellers. What can I take away from this, guys, in my business to minimize my exposure, my likelihood of getting sucked into one of these? What can I do?
Well, you don't have any duty to investigate, so that's important to remember. But you as a broker have a duty to, disclose things that you know personally. So, if your seller has provided you specific information that would potentially have a material and negative impact on the value of the property or somebody's decision to purchase, that's the kind of information that needs to be disclosed. And that's on you and on the seller, because once you're made aware of it, you have a duty also. So, there's that. And then just being very careful, obviously, when you list the property, that you're disclosing things accurately. Not, we all sometimes, when the market is up, we have a lot going on. You just need to pay attention to the detail and make sure you're not putting anything out there that's completely false or inaccurate. We've seen situations where a broker will say to a buyer that there's a specific condition of the property and they don't necessarily get an inspection, but maybe in reliance on that representation from the broker. And that's created liability for the broker because they've said something that was materially relied on by a party. So you have to be careful when you're doing that. Don't talk about things you don't really know about, you know, and if somebody comes to you with a specific question, you know, maybe say you need to look into that, or tell them they need to hire a professional to do a survey or do an inspection, or go get a, you know, get information about sewer versus septic. That is a very big one. We see a lot of cases involving that specific issue. So yeah.
So we have a question that follows in this area. Mark is asking, with this highly aggressive market where we have, and we have homes we're seeing 24, 26 offers. And as a result, we're seeing buyers trying to be more aggressive, right? They're waiving inspections, they're waiving a release for earnest monies, all those different issues. So what can we do to protect our agents and our company?
Well, waivers are, from my perspective, a wonderful thing. Nothing makes me happier to know that in defending a client, the other side has said, we waive any ability to say that you didn't tell us something that you should have told us. So waivers are certainly good from my perspective. And to go back to what April commented on, you know, there's so much work now out there. The real estate market is so hot. It's not, the things that I see are not a result of people necessarily doing bad things or doing things that they knew about that they shouldn't have done. It's just because we're too busy in our everyday life to really stop for a moment and be aware of what's going on, be aware of what it is about this house that may be an issue, talk to our clients about the home, about whether they've ever had it inspected, whether they've ever done, you know, work on it. You are not required to investigate, as April pointed out, but you know, you really should have a good understanding of what it is you're selling, and be aware of what your client knows potentially about things that may be problematic, so that you can have that clear communication and make sure that you're disclosing everything that you need to disclose to protect both of you, really.
Mike, that question to you. What can we do to help protect agents and licensees?
You know, one thing that I get a lot is when clients call in and tell me they have a claim, is they always say, I had a bad feeling with this person when I started working with them. So just use your gut instinct. If you don't have a good feeling about somebody you're working with, sometimes you just got to walk away, because I've seen some whopper claims, and those claims, they hurt your rates for 5 years. So that's the number one thing I always tell people. I mean, with your gut feeling, if you don't have a good feel about this person, then there's probably a reason.
Well, Mike, that brings up a good question. Are there any transactions that are more risky? I mean, like broker-owned properties, for example. I mean, that comes to mind. Are there anything that's more, that you're saying that's a riskier transaction for us?
Yeah, hot spots right now outside of property management, agent-owned property sales. That's also probably one of the biggest claim denials we get too, because a lot of times you see a good opportunity, you want to flip the property. Well, if we cut a few more corners, we might make a little bit more profit on it. And that's where your claim comes in, is that they find out that you cut some corners on the work. Maybe you went with a little bit, somebody that's not as good at doing, or a little cheaper, I guess, a real bargain on the flipping. And they'll come back and the electrical wasn't up to code in the area, something like that. But that's a really big one. And on top of that, review your E&O policies, because almost every single one has specific criteria for coverage to apply when an agent sells a property they own. Typically, it's a combination of a property disclosure form, a standard sales contract, a home warranty, and a home inspection. Some of them accept waivers, but you know, with Brian and I, we tell our clients to do all of those, because to my knowledge, if you have those, then I've never had a problem with coverage. But there is a few carriers that say you have to have the home warranty. We won't accept a signed waiver that says they chose not to get a warranty. So if you always do that, then you switch carriers, you should potentially have coverage on it if the claim does come in. But that's kind of the number one or next hot spot on what we see claim denials for.
Brian, how about you? What are the biggest risky transactions that you see out there?
Yeah, and just to piggyback on what Mike said, there are carriers out there, what are referred to as non-admitted carriers, that don't allow such actions, representing yourself as a seller. So, check your policy and just make sure you're checking off everything. And odds are good no one on this call has that type of a policy, but it's certainly worth looking at. Beyond that point, when you're purchasing as a home, as an agent or a broker, you will not have coverage on most policies as well. So just understand that. Now, with that said, 90% of all claims come from the buying side against the seller. So, it's not a big concern I have. I do have concerns anytime we see business brokerage tied to anything. Real estate professionals, and I think most of you on here will say I'm no business broker. I'm nowhere near doing anything like that, but you may sell a laundromat or a pizza joint and you sell the real property with it and the business went along with it. Certainly make sure that you have disclosure stating you're not a business broker. Get the appropriate people involved, and just make sure your policy is going to cover that real property when it's sold through as well. That with the economy the way it is, especially in retail and dining and that type of thing, I have concerns on that commercial piece there.
Brian, I'm curious, when it comes to claims that get denied, what's some of the more common reasons?
Yeah, we don't see a lot of claim denials. I'll go back to what Ken talked about several minutes ago. Not turning a claim in at an appropriate point is probably the number one denier. Mike, I would think you probably said the same thing. It's one of those things that, your policy comes due to renew on October 1st. When Mike and I send out the documents we need to bind coverage, we let them know, please poll all your agents and find out if they have any claims or possible claims, potential claims, anything that might make sense. And we want to make sure those are turned in. If we roll them to a new carrier or even the same carrier, it's possible that new carrier would deny coverage because of prior knowledge before the expiration of the policy. So the analogy I use when we talk about agents and brokers, unless you're writing the checks, we're kind of like children sometimes. We spill milk behind the couch. Eventually the milk is going to smell, even though they don't tell mom and dad. So please tell us about the spilled milk and we can address it a lot quicker.
Spilt milk. We should write that as a policy statement. I like that one. If we could change things, if there was some way we could change things, we're always trying to make things better. If you had like a magic wand, let's just say, and you wanted to make a change in this process, what would you be? Ken, I'll start with you.
Well, I have an issue with the frivolous lawsuits that are created out of thin air that end up costing licensees and firm owners money. I got a big issue with that. So my magic wand would have to do with something where you can't just create cases out of thin air and then make a money grab to the insurance company, knowing that it's cheaper to settle than to prove you're right. So that's a big wand, but that's what I would do with it.
And from a legal side, April and Shane, if you had a chance to change some things, what would you think should be done?
Well, I'm smiling because I get asked that question every time a case settles or is concluded at trial. I sit down with the client and the client always looks at me and says, what could I have done to avoid being here? Not that I don't like you, Shane, but the last 12 months have not been my favorites. And the answer I always give is the best thing that you can do is document what was happening at the time it was happening. That really is key. Making sure that you're communicating to the people that you're working with, making sure that you're documenting what happened in the file. That really is the single most important thing that you can do to protect yourself down the road, because you can't control when somebody else files a lawsuit. You have no control over that, unfortunately. Even if you didn't do anything wrong, as Ken has pointed out, the only thing you can do is make sure that you're ready to respond to a lawsuit when it does get filed.
And I imagine double checking, especially where these are common key areas with claims and compensation. What did we talk about? Sewers and septics, or some of the more common things. That seems like an automatic double check in that process, doesn't it? So Mike,
I
how
would
about
also-
you? I was just curious about now, you've had a chance to, from your perspective, what would you, if there was a chance for you to change things, what would you do?
And for our clients, if I could change one thing, I would hope for like what Ken's dealt with, a few frivolous lawsuits where, it's cheaper to settle for 30 grand than to go through court and run up the attorney's bills to potentially 6 figures. If you get dismissed from a claim, you're not found at fault, then those wouldn't penalize your E&O rates for 5 years. That way, if you did something malicious and you earned it, yes, you should be paying a higher rate. But I mean, at the end of the day, for our carriers, Travelers, Hartford, whatnot, it's however much money's spent, it's still money out of their pocket, and they have to raise your rate due to it, whether you were right or wrong. And I don't think the realtors are wrong. A lot of the stuff I see come through. So that's probably wishful thinking. I don't know if it will ever happen, but if it does, Ken will be a really happy man.
And Brian, from an industry perspective, what do you think? What is there a magic wand answer here you'd like to change something?
Yeah, I wish that existed. And I'm going to kind of steal everybody's thunder here. Tort reform would be wonderful. We've seen a little bit of across the country, but it's probably not to the level it needs to be. More than anything, make sure you have everything ready for April and Shane when they pick up the phone and give you a call. The better prepared they are, the better you're going to do through this whole process. Make good decisions by good policies that have great claims handling. And I'm sure April and Shane can tell you horror stories about some carriers out there. But just trust the process and let it do its thing. You have a deductible, you're probably going to have to pay it. And whatever you do, don't miss right and wrong, you being right or wrong, with dollars and cents. Because if you want to go fight this thing, they're just going to go deeper in the pockets of the attorneys on both sides. Sorry, guys. And eventually, just trust the judgment of the insurance company and your attorneys. These people are professionals. They know what they're doing. They're going to steer you in the right direction, assuming they're honest, good people, and most of them are.
What kind of last area? I was just thinking about this. How the commonality of this? I mean, Brian and Mike, is there a number that you attach? Let's just say there's 100 transactions on average. How often would you see a problem or a claim erupt from those transactions?
A lot of that goes back to where you're located. California, it's probably between 500 and 750 transactions you're going to hit for a claim. Texas might be 1,000 or 1,200. Most of the country, if we look at the hard data, they're telling us once every 1,500 transactions. Carriers are notorious for not really giving us full answers all the time. But I'd go to Ken's point he made earlier, or it may have been Shane, I'm sorry. You can't control who's going to sue you. The odds basically say if you do 1,500 transactions or whatever the number happens to be in your neck of the woods, you're going to get hit for a claim. For arguments purposes, for this conversation, I'd say once every 1,000. But once again, just do everything right across the way and hope things work right.
And April and Shane, what percentage have you looked at are really valid or really they're the kind of claims that end up going to a strong case in court and you're most afraid of? What percentage of cases do you see?
Most of the ones that get to my desk are questionable, and the reason is because if there is merit to them, they usually resolve before they do get to me. So I would say I can confidently say the majority of the time that I get a lawsuit, there is definitely a defensible position, if not an outright meritorious way to get the lawsuit dismissed even before we go to trial or even before we even talk about settlement. In terms of the total number of cases that I see, it varies, really does vary depending on the economy. When there's a downturn, we see more. When the economy is good, we see less. And it sometimes happens in groups. I'll get 2 or 3 in a row. And then there will be weeks or maybe even months where I don't see anything. So it really is hit and miss in terms of when it gets to us.
And what's the appetite from our court system? Do we see a lot of court-ordered negotiation or mitigation, or is it pretty much let's just go to court and settle the facts?
Judges are much more willing at this point to order parties into mediation or alternative dispute resolution, not just once, but multiple times before you go to trial. It's encouraged, it's sometimes ordered. And with these kinds of claims, we often don't see them going all the way to trial. It's usually a settlement process before trial, but occasionally you'll go through a trial.
Do you ever see binding arbitration being imposed?
No, there is an arbitration process through your guys' association that I'm aware of. We're usually not involved in that. By the time we get claims here at our firm, it's beyond that process, and parties would need to agree to alternative dispute resolution or be ordered into it, in my experience, unless there's a contract provision that calls for it, but usually not.
I would agree with that. Usually, if you're going to be in an arbitration, it's because the contract requires it. In Washington, in most counties now, anything that has a monetary value of less than $100,000 is subject to what's called mandatory arbitration, which is a court-required process that actually ends up you get to an arbitrator who is an attorney in the community who's agreed to serve as an arbitrator. You get in front of them far more quickly than you would get to a jury trial. So it's either contract, mandatory arbitration because the amount at stake is less than $100,000. And then, as April pointed out, if that's something that the association requires be arbitrated.
Wow, this has been a great conversation today. We're getting close to the wrap up here. I'd like to give you all a chance just to talk a little bit about if there's anything we've missed or if there's any advice that you think we should pass along. Tom? I think you're still muted there, sorry.
Yeah, thank you. I had a quick question, and it has to do with the discussion a little bit earlier. You guys talked about the threat of a claim and making sure that you pass that on and get your E&O carrier involved early. I don't recall hearing what effect that has on my premiums. If I give you 7 threats of a claim in a year and yet nothing goes to, nothing comes of it, how much does that, because my car insurance is going to go up every time I call my insurance guy and say I might have bumped into somebody.
Yeah, and I'll jump in here, Mike. The reality is it's a double-edged sword. It'd be real easy for me to say, yeah, it's not going to affect you a bit. The reality is if you already have claims on your policy, say you've had 2 in the last 5 years and you turn in a couple of quote-unquote incidences, they are going to be labeled on your loss run. But assuming that they show, and when I say loss run, it's basically just a document that states what kind of claim history you've had over the last several years. But it's going to state in there that incident, but it's going to show $0 spent on it. Most of our carriers in today's market understand that this happens and they're comfortable with it and they don't ding you for it. Not to say that there aren't a few out there that may rough you up a little bit, but trust me, you would rather turn it in and have somebody ask lots of questions than not turn it in and have that $500,000 or $1 million claim that didn't get covered. And we see literally claims that pay out $1 million. We don't see a lot of them, but they do occur. They are scary out there.
Yeah, and to add on what Brian was saying there, double check your policy. A lot of them have a free risk management hotline. Sometimes it says 1 hour. I've talked to the carriers. They don't usually limit it to 1 hour. They really want you to call if you've got a prudential incident, and if they can mitigate it ahead of time, then it's good for everybody. So I'd rather over-report than under-report. I don't notice a lot of premiums skyrocketing. I can tell the story to my underwriters and say, well, if he's got 6 things that showed up on his loss report, well, here's what happened. He's a cautious person. We don't want any surprises, but nothing's happened, and that's what they want to hear.
I've got a question. I'm in the audience and I want a takeaway here. What's like the biggest mistake, top 1 or top 2 mistakes licensees are making out there, so that I know what those are? So in my practice, an alarm goes off in my head if I'm in that situation. What are the licensees doing wrong? Like the top 1 or 2 biggest mistakes?
I would say living in the gray area. And we kind of take this attitude at Pro Group as well. When there's no gray area, we normally don't have problems. We do look at it as right and wrong with everything. And typically it has something to do with a non-disclosure issue, when your seller is completing their disclosure statement on their house, anytime they ask what if, the answer is yes, put it on there. And that is going to help you. It stops the claim before it ever happens. And, you know, some states and some attorneys, and I'll lean on April and Shane, would tell you, I don't even want you in the room when they're doing it to give advice. I'm going to leave on the locals there to make that call, but that's something to consider as well. But personally, if I'm involved, I'm telling them, if it's a question, answer yes, give some details.
April and Shane?
I completely agree with that. Communication is key. You're often, most often better off by putting it in the open, communicating it, getting out there, disclosing it. Like I said, by far the most you see are misrepresentation claims where the argument is over, did you know it? And if you know it, why didn't you disclose it?
Yeah, there's a catch-all in that seller disclosure statement that basically it will get, if there's not a specific question that, you know, answers what you're asking or what your client's asking you, that's where it's going to fall. You know, basically it comes down to, if a buyer would have maybe potentially made a different decision because of the omission, it's going to be applicable and should have been disclosed. Or if it has a material impact on the value of the property. And those are by and far the biggest issues, are misrepresentation claims specifically involving the seller disclosure statement. I think that brokers, frankly, need to be talking to their clients about the seller disclosure statement. So I don't know that I would agree about leaving them alone to do it on their own. You don't have a duty to investigate, but I do think you need to be able to talk your client through the process to do your job. So that's what I would advise folks, you know, and if they tell you something, make sure it gets disclosed because you're part of that process too.
But my question also is now is looking forward, are there any potential areas that you see sort of emerging? Christy asks, for example, discrimination lawsuits. Do you anticipate outside of property management issues, is that going to be an emerging area that we should really pay attention to? Or what other areas are we not thinking about? We'll start with you, Shane, and April, and we'll go over to Mike and Brian.
You know, I haven't seen a lot of those yet. I anticipate that they will go up though, especially in a rental market that is so robust. And frankly, you know, is there a really big bubble on the horizon when folks have to start paying rent that maybe have not paid rent because of the moratoriums on evictions? That might be something that gets to be pretty big 12 to 18 months down the road when the landlords are going to start looking for their back rent.
I think we're going to see quite a big spike next year, probably as soon as the moratorium lifts, in part in this state and also across the country. In terms of discrimination, I feel like that area is ripe right now. I'm not personally seeing it, but I am anticipating it coming through, especially beginning next year.
Brian and Mike, same question to you. What areas are emerging that your industry is watching out for, or see as emerging?
So like they said with the discrimination, I really can't think of too many situations outside of property management where I've seen it. Every once in a while it's alleged, but most of the time it's so hard to prove. It's just kind of a he said, she said, and it seems like it's gotten thrown out from the few suits that my clients have had. I know we have some carriers that are getting a little skittish on kind of construction development, so that's an exposure that if one of the realtors, they own a construction company, or like Ken owns a construction company, they're building homes and then selling it back through the office, that there's some concern with jobs and everything, that lawsuits could come in from that. So that's tightened up a little bit from underwriting. Property management's really big. I've heard that from 2 carriers in the last couple weeks. And then the business brokering, there's a few carriers that aren't even offering that endorsement right now, with just a lot of concern that they feel that there's going to be claims coming in from it inevitably.
Brian?
Yeah, to the discrimination question, I tend to agree with Mike. the kind of running joke we have is the only color that real estate professionals see is green. We are driven to make money and do our job. I'd be shocked if anybody here is really discriminatory when it comes to these type of things. Although once again, you can't control what's happening on the other side. Just once again, make sure you're crossing your T's and dotting your I's. Another market that concerns me a little bit, I know a lot of offices have ties to mortgage companies, some type of mortgage broker, whether you have them in-house, if you're referring to a specific one, that kind of thing. I would certainly make sure that they have some type of E&O coverage in place. These people are beyond busy right now, and it is difficult. It's rolling into the title business and mortgage brokering. When they do that much in a short period of time, that concerns me that more claims are going to come through. Cyber coverage is something that we often talk about as well. Make sure, folks, you're not ever emailing in any wiring instructions to your buyers. Make sure that is always verified via telephone.
It's a perfect answer. And then we have a question that emerged, and it was something I've been thinking about. So when I bought my last house, one of the things that helped was I wrote a really nice kind of a marketing letter about myself, right? Who we are and how we're going to use the property and that sort of a thing. But in terms of a business sense, is that sort of a thing that could be the groundwork for a discrimination case, for example? And then we have a question, the reason why I asked this, in our chat group here, that says, should we ban those? Or should we, just from a legal standpoint, is that something we should consider removing from the process? April and Shane, what do you think?
Well, it can be problematic if you do that, if what you're saying could be interpreted as some sort of warranty. In other words, if you're saying either this home is going to be right for you, here's all the reasons why, and it turns out that something is a little different than what was on the page, or someone says, I told you what I needed in terms of what I was expecting, here it is all in writing, and you didn't deliver what you knew I wanted. And then from the broker's position, sending out flyers or letters on the services that you can provide and how great you are and the things that you do to work for your clients, that's something that they could point to down the road and say, you told me that you were going to do X, Y, and Z for me, and you didn't deliver, and you breached those, because those are warranties now. So it's always tricky.
This is me as a buyer. This is me as a buyer saying, you should pick me because I'm going to love this house just the way you did, adding an emotional element to it. What do you think about those?
Well, I can see the attraction of it when we're in a hot market where you're getting multiple offers and you want to stand out. But anytime you do that, if this, in particular, the seller is potentially opening themselves up to a claim of discrimination from the other folks who are making offers who don't win, whether or not there are merits to those claims, I don't know. I guess it would depend on the facts and circumstances. But, there are obviously things that you can't say, you can't base it on, race and gender and those kind of things. But I would say if you're going in that direction, maybe having a verbal conversation would be better than a written letter, or something to that effect. I worry about putting something out there in writing that could form the basis of a claim, regardless of its merits, and that we won't know until we see what they actually say. But I think you're opening yourself up to potential claims when you do accept those.
And that last area for all of this is COVID. I mean, are there any anticipations moving forward that issues around COVID may be grounds for an E&O complaint? Thoughts here?
Yeah, our carriers, for the most part, are not responding to anything COVID related at this point. Your general liability, you might have a work comp claim. There are a lot of things out there that are potential. I do feel that the directors and officers level, they are going to get hit this year. That's another discussion. But with all that said, the challenge we're going to have is Shane was in my house. How did he give me COVID, or how did I give him COVID? And I don't believe that we're going to have anything to stand on. Doesn't mean there won't be attorneys and there won't be lawsuits, but I really don't see a whole lot going at this level specific to what we're talking about today.
Okay.
Getting back to the insurance policies, there are a lot of policies that have virus exclusions. So there may be an exclusion to your policy that says we don't insure any loss that results from a viral infection.
Okay. So great information today. And we squeezed a lot into 1 hour. And I want to thank everybody for joining us here. And let's walk around the room one time. Ken, any thoughts about what we're not talking about here, or just what are your thoughts from what you've heard today?
You know, I just like the takeaways. Report it to your carrier if there's a threat. Document material communication. I know a lot of licensees in Washington kind of rolled their eyes when the DOL says you got to have material communication. They're doing that to help us. So material communication and report it. And I like what Brian said. We get in trouble, or where we get in trouble the most is when we live in the gray area. That was a takeaway statement for me.
Mike, how about you?
You know, I don't have a whole lot else to add. I appreciate you guys having me on to share my experience over the last 13 years of doing this. A lot of times you guys are going to get named in lawsuits and you didn't do anything wrong. It stinks and it's going to cost you money, but you know, they could try and sue me for a transaction you did, and I'd have to go spend my own money to get removed from the lawsuit. So it's just kind of tough, but hey, the market's good. Keep selling a lot, right?
Shane and April, how about you? I love the idea that you passed along about disclosure statements. I mean, if there's an advice I could pass to everyone, it's disclosure, be careful. Any thoughts?
It's a big one. We would probably be beating a dead horse here, but I would say obviously document, but know your policy. And if you have questions, make the phone call, talk to somebody, become educated about it, because the more information you have, the better. And then, you know, you'll be able to protect yourself and know what hoops you need to jump through to make sure you're covered if something does happen, because we are very expensive to hire. You don't want to have to pay out of pocket if you just miss a deadline. And then, you know, just cross the T's, dot the I's with your documentation and paper your file to protect yourself.
Is there a statute of limitations in Washington?
Depends on the type of claim. Yeah, you know, we've got breach of contract claims are 6 years. You've got tort claims are generally 3, I believe. So you'd be looking at potentially several years after the close of a transaction for a claim to actually expire. And that can be extended by the discovery rule, which I think was mentioned by one of the brokers earlier. So, I mean, potentially you could be even further beyond those depending on the facts.
Great. And Brian, any last thoughts here, or things we haven't covered, or things you'd like to pass along?
Thank you all for allowing me to be here. No, I kind of agree with April. Go lean on an expert and ask questions. Call your broker, call your attorney, call your insurance company. Odds are good as you dig through an insurance policy, it's going to kind of melt your brain or put you to sleep. April and Shane are experts. They're always going to have answers for you, and they're going to help you on your behalf. And if we can ever help out on our side, feel free to give me a buzz or Mike, and you know, we'll hope we can answer any questions you have.
Thank you, Brian. Tom?
Oh, I'd just like to thank everybody for being here today and for sharing your knowledge and your expertise and allowing us to pick your brains a little bit. I think you'd agree that it's to all of our advantage to be forewarned and forearmed than it is, you know, I've always asked my clients, when do you want to meet their attorney, now or later? It's better to meet them up front and deal with the issues before anyone's harmed. So thank you very much. Appreciate your time today. Ken, thank you, and for the membership committee with their input. For the benefit of those listening, please keep in mind that our goal is to provide you with these events so that they're beneficial to you and assist you in your day-to-day business. If there's some topic you'd like us to discuss or like us to put a Zoom together for, we'd be more than happy to do that. Just let us know. And thank you all very much. Have a great day. Stay safe.